Welcome, everybody, to the Labor and Employment Law section of the Orange County Bar Association. Today, we're going to discuss the key case developments for the cases published during the month of September of 2025. I am Javier Rivera Carbone, your host, workplace investigator, attorney. With us today this morning is Alan Berry, who is part of the law firm of Wood, Smith, Hanning, and Berman, and she dedicates her practice to representing employers mostly. Michael Robinson is an employment attorney in Orange County who dedicates his practice mainly representing employees with the Robinson Employment Law. Thank you, Michael. Thank you, Alham, for being today here and willing to discuss these cases. You received today a link to download the key case developments summary prepared by the law firm of Payne and Fears. And we're going to go over this summary beginning on page 3. I believe that on page 3, there is a case that deals with religion. And Michael, I believe you're going to discuss that one.
Yes, Javier, thank you very much. This is the Detweiler versus Mid-Columbia Medical Center case. It's a Ninth Circuit case that happened in Oregon, but it's about religious discrimination and accommodation under Title VII of the Civil Rights Act and also under Oregon's Anti-Discrimination Act. Those laws are very close and very similar to the California Fair Employment Act. So it is very instructive. So what happened here was the plaintiff was a privacy officer and director of the health information for a hospital in Oregon. The state health authority during the COVID pandemic issued a vaccine mandate for all employees in the healthcare system. And the plaintiff objected to the vaccine based on her religious beliefs against abortions because she said the vaccines were created using fetal cell lines. So the hospital granted this exemption from the vaccine mandate, but also required plaintiff to wear some, protective gear in the workplace and to take weekly COVID tests using the nasal swab method as an alternative accommodation. Now, the plaintiff stated that the nasal swab test used harmful chemicals and would conflict with her religious duty to protect her body as a temple for the Holy Spirit. And plaintiff proposed an alternative accommodation of using the saliva test or being a full-time remote employee. So the hospital rejected these counter proposals because the saliva test takes at least a day, maybe two, to get the results. And the plaintiff's department saw an increase in complaints and also just dissatisfaction with the plaintiff's work when she had worked full-time remotely before. So the plaintiff refused to do the nasal swab, and she was placed on a leave to decide, how she wanted to proceed. The hospital extended the leave and proposed another alternative accommodation to say, perhaps you could go to a different position that would be 100% remote. And the plaintiff did not agree to do that, and she didn't agree to the nasal swab test, so her employment was terminated. She sued, and the case was dismissed under 12b-6 for failure to state a cause of action. The district court essentially said that the plaintiff's decision or determination of what was harmful with the testing was not premised on any religious text or tenet or teaching, but rather based on her own research and scientific medical judgment with regards to the chemical that was used in the nasal swab test. And the Ninth Circuit reviewed this and decided to affirm the district court's decision. And its reasoning was that the law protects religious beliefs, but not secular beliefs, even if they are communicated using religious language. The court had to draw a line and stated that the courts need to look at the belief at issue to determine if it is truly religious or secular. And just linking it to a religious principle is generally not enough to make a secular belief into a religious belief. The court was requiring some sort of a nexus between the religious belief and the refusal for the plaintiff to undergo testing. One of the interesting examples that the court used in trying to draw the line was they said, an employee could say, my body is a temple and exercise is good for my body. My research shows that exercise is most effective in the morning, so I should get a religious exemption to avoid any morning meetings. The court said that they had to draw a line somewhere in that if they just took a more open approach to just allow any sort of belief with that's presented with religious language to allow an accommodation, that it would open the floodgates for all sorts of beliefs, some being secular or all sorts of secular beliefs being needed to being accommodated. So the lessons we have here specifically from the court is that we need to look at the specific objection and the basis for the objection to determine if the reason the employee is requesting the accommodation is something that's entitled to protection or not. This analysis could also be applied to other protected statuses. So what the courts really want us to do is look at the reasoning behind the specific basis for the accommodation being sought. Is it truly something that's based on a religious text or tenet or teaching, or is it something that I found my research shows that this could be harmful, so I don't want to do it? That's essentially where the court drew the line. Now, this is not a very clear line, as there's a pretty extensive dissent that is stating that the court, Ninth Circuit, should have followed the many other circuit courts in providing a more lenient standard. There were at least one other court that had agreed with the Ninth Circuit, but what this essentially does is it sets up a split between the circuits. So there is a good chance in the future that the U.S. Supreme Court might pick this issue up in the future. Essentially, from a plaintiff's perspective, employees should be very specific in their requests for accommodation, whether they're for disability or for religion or any other protected status, and providing the reasons to the employer so that they can do this analysis. And I think both attorneys on both sides should certainly advise their clients on how to engage in the interactive process. I think that looking at this case, you see that the party that decided, well, I'm not going to further engage in the interactive process is essentially the one that lost. And I think that a lot of times we do see that. So that's another lesson from the case. But Alam, would you provide your perspective from the defense side?
Yes, largely in agreement with you. The interesting thing that I found about this and reading the opinion is that the court made a comment to the effect of the test is whether or not the belief is secular versus religion, but also stated you can't examine the sincerity or the reasonableness of the belief, which creates a much more subjective analysis of whether or not the request is reasonable or could be accommodated, or whether it's even based in religion, because at least with a disability, you have a second opinion that's verified by a physician, and it's based on something where there is a general baseline understanding of what limitations are, what medical conditions are, and things like that. However, with this does pose a lot of difficulties for employers because religion, a lot of people, even within the same religion, don't agree on things, and there's sects and subsects. And so it gets very difficult to navigate. So the interactive process is exceptionally important, both in ensuring you, as the employer, get as much information out of the employee as possible for you to fully assess what's going on and how you can resolve this. And because of its complexity, it does require some discussion. But the thing that was difficult about COVID is, even though it's now 5 years later, and I think we all forgot the trauma of that time period, it does make navigating really difficult situations even harder. So the conversation is really important, and assumptions should not be made.
It's interesting from my perspective that this was a case at the dismissal level. So this is an attack on the pleadings only, no discovery, just what was alleged. And in that sense, bringing the case to California, the reality is that it is possible now for both sides to be mindful of that. From the plaintiff's perspective, it's important that they make a connection to a held belief, which is based on religion, to the conduct of the employer to survive this type of attack. And from the defense side, it is possible maybe for a court to dismiss a case at the outset by an attack on the pleadings. Interesting. We're going to move on to page 4 of the materials, and in that page, there is a case dealing with harassment. Alan, I think you're going to discuss that one.
That's me. So that's Krutbosch versus Bakersfield Recovery Services in the California Court of Appeals. So this one is a very interesting case, very fact specific. So I'm going to run through the key facts because I think they do matter. In my view, this opinion was a little bit difficult to follow, even though it facially seems really straightforward. Effectively, plaintiff, the employee, was subjected to sexual harassment by a coworker outside of work, involving very sexually explicit text messages and photos, propositioning him for sex, appearing at his home uninvited, and other rather egregious conduct. And this all happened outside of work while plaintiff was on a leave of absence. Upon his return to work, he complained to the program director and HR. The director simply stated there's nothing that could be done about this, and HR engaged in conduct or made comments that plaintiff at least alleges that he perceived as sarcastic and harassing towards him about his complaint, and that involved making a social media post of a whining dog with a caption stating, "This is a work day at the office," and then making a comment to plaintiff that I hope you're not getting any more photos. So within a short period of time, plaintiff resigned, filed a lawsuit alleging harassment, discrimination, retaliation, all of those things. This case was on the demur stage, so this was all a matter of whether or not he sufficiently pled the claims. And there's two portions, published and unpublished. In the published portion, the court discussed the sexual harassment. This is a little bit, in my view, complicated and a little bit circular. So there were 3 points of analysis: whether the conduct was sufficiently work-related, whether the employer knew or should have known and failed to act, and then somewhat whether it was sufficiently severe or pervasive. And a lot of different subparts were just joined and separated at the same time. But eventually what the court ended up finding is that the sexual harassment was not considered work-related, and that by the coworker specifically, because there was nothing to suggest even pretextually that it was work-related. It happened entirely outside of work. There was nothing that even connected the employer to it, whether the use of an employer-provided cell phone or email, a work-related event, nothing like that. So there was a true disconnect here between the employer and the coworker, so that it's just they knew each other from work. And so the court found that the conduct wasn't work-related, and theoretically, one would believe after that that then there's no sexual harassment claim. However, because the court then went down to discuss what the employer's response was, and effectively the court says that the statement by the director that nothing could be done at work in and of itself could have been viewed as altering plaintiff's environments in a severe manner. So going back generally prior to this case to the concept of coworker harassment, the standard is whether or not there's, harassment occurring and whether the employer knew or should have known and adequately addressed it. Even though the sexual harassment occurred outside of work and had no nexus to the work, the court is effectively finding that the employer is still required to do something. And then on top of that, the court looked to the conduct by HR, regarding the comment and post on social media, and basically said the collection of the severity of the coworker's conduct, even though it was outside of work, coupled with the refusal to do anything about it and seemingly sarcastic comments in and of itself could suffice to create a hostile work environment, and so plaintiff sufficiently alleged sexual harassment claims. However, on the flip side, with the discrimination, retaliation on both FEHA and whistleblower, the court found that plaintiff did not sufficiently plead a constructive discharge claim. And the basis of the court's opinion, at least the way that I read it, is it's because plaintiff did not come back to the employer and try to explain to them, hey, this is really affecting me, or I'm under a lot of emotional distress because of it, and I'm now unable to do my work. And so quitting was only one option, and he chose to take that route instead of at least trying the others. And then the court also noted that in this specific scenario, the inaction by the employer and their comments were not considered an adverse employment action, because it was not a course of conduct that could be viewed as effectively preventing plaintiff from complaining or availing himself of the HR process. But the key takeaways here on the employer's side, there's been a number of cases over the years about whether or not harassment outside of work is actionable. And there's obviously a distinction between coworker versus supervisor harassment. But in my view, this effectively eliminated the distinction between outside of work versus inside of work, because at the end of the day, it seems to have come down to whether or not the employer did something about it. So whether or not it happened in or outside of work, if there are two employees that come together, it seems like it's going to come into work regardless. And so from my perspective, an employer should always take any claim of sexual harassment, whether in or outside, seriously, especially with a coworker where they have that extra step where they can do something about it and it's not strict liability, and they need to do something. It's not clear from the case what is sufficient, but it sounds like what is necessary is an investigation, an admonition to the harassing employee, and then trying to separate them or shield the plaintiff from having to interact with them. And even though the court found what it found on the constructive discharge, I think this is very fact specific based on its analysis, and I don't think it's a clear win for employers. Because if plaintiff had come back, then the analysis would have continued, and it depends at the end of the day on what the employer does. So I don't really think this changes much in terms of the reality. I think it was kind of a circular way to kind of get to the same point that employers have to investigate everything. So I think we should safely assume that. And the key thing to me is HR should not be friends with employees on social media.
That is a lot of discussion for a case that was handled at the pleading stage. Michael, what do you think?
Alam, I agree with your positions. I do think, though, from the plaintiff's perspective, it's a pretty good case for plaintiffs, because it's essentially you don't have to prove that the employer did something or what their reasoning was for it to continue your case. Essentially, the proof of this case was that the employer didn't do anything, and that the director said, "Oh, well, there's nothing we can do about it." I think, certainly from a plaintiff's perspective, it's easier to prove those kind of claims, and I know a lot of the case did get cut out because of just the facts of this specific case, but the harassment and the failure to prevent claims, those are essentially going forward after this appeal. I think certainly that these two individuals had their only relationship, the harasser and the plaintiff, the only relationship was knowing each other from work. And so I think that it was certainly reasonable for the individual to bring that up to the employer to say, hey, look, this is what's going on. I think, again, at the very least, I think that it would have been reasonable for the employer to go to the person and say, hey, we got this complaint about you. Make sure you're not doing stuff like this. Can cause a problem. Or I think potentially even do an investigation to see if this person's doing this to anybody else, or if there is something that she's doing there in the workplace that wasn't reported. I mean, like I said, I think things like this certainly should have raised their ears, and I think the fact that they did the ostrich move of putting their heads under the sand and saying, "Oh, that's not here. We don't have to worry about it." I think that's really what got these guys potentially in trouble. But I do think this issue with the social media thing is, I'd like to really know more facts about that, because was the plaintiff a friend of this person in HR, or did somebody at the law firm for the plaintiff, did their team look at this person's social media? I would say certainly that's something that I think all plaintiffs' attorneys should be doing is, if you know the decision makers, take a look. What are they posting? maybe sometimes you get nothing, but maybe sometimes you get lucky. And this, the gal with this picture, and she put a little, what was she put a little word there, LMBO, which means laughing my butt off. I mean, that to see like, oh yeah, especially with the whining and whining, complaining, it's like I said, those go hand in hand. It's really easy for them to take that and say, well, here's your HR representative showing what the company really thinks about these complaints. I think that right there, in addition to just saying nothing, I think that was really huge for saying, yeah, this guy's got something going forward.
This is an interesting case to me because, again, at the pleading stage, just an attack on the pleading, no evidence, no discovery, just the allegations. So there is a takeaway on the legal side, which is for plaintiffs. Make sure that your pleading explains and outlines why this could be a cause of action, in this case for harassment, and more importantly, for failure to prevent. But there's also a practical takeaway for employers because the duty to investigate, when is it triggered? And apparently the court is saying, like, even if technically you're not responsible for conduct outside of the workplace, you may have a duty to investigate. So maybe an internal investigation, maybe an external investigation, but definitely the court seems to be sending a clear message that doing nothing is not enough. But the reality is that how much can they do? Nobody knows. This case may come back interesting under FIHA. So this may come back in different cases in the future. Moving along, and we're going to mention some cases now. We're going to concentrate on the holdings. We're going to turn now to page 6 of the materials. In that page 6, there's a case that I find fascinating about attorney's fees. Michael, you're going to mention that one. Yes?
Yes, this is the Braunstein versus Department of Consumer Affairs case. It's it's essentially a case that was a failure to accommodate disability discrimination case against a state a state agency employer. But the reason to really bring it up is because this is a second appeal in this case that was very hard fought. And essentially the verdict was for about 3.3 million in damages, but the appellate court upheld $4.9 million in attorney's fees. They upheld not only the fees and the rates, but also the multiplier that the lower court had provided. And I think, the real lesson for this, especially this time of year, it's a bit of a scary scenario for employers that, there was a 998 for $600,000 and 3.3 million is a pretty big verdict. But on top of that, another close to 5 million for attorney's fees. That I think the lesson really is that, maybe employers should take the settlement more seriously instead of just, fighting the case on principle that we fight. Like I said, this was a second appeal. There was a lot of discovery. The company really just fought this case or the state fought this case as hard as possible. And the plaintiff spent 3,000 hours on the case. And I think the lesson is, just because you fight hard, doesn't mean you're going to win. And that goes for either side. But the first line of the opinion, I think, really says it the best. It says, when the plaintiff files a case with the perspective of recovering attorney's fees, the defense is fully entitled to fight hard. But the defense does so knowing it may end up paying for all the work for both sides. And like I said, I think that's a good lesson for folks out there to, take these settlement discussions seriously and not just fight on principle.
Alan, what do you think?
What I think is for defense counsel, be sure to raise concerns about block billing over litigation and administrative work at the trial level, because if we have strong arguments, it's usually those, and they failed to do so in this case, and they waived it on appeal. So we got to do our due diligence at the ground level.
Agreed. And also, not only that, if there is an issue as to the fees, it should be brought up at the appropriate time when the court is considering how many fees to award. But also, it seems to be a case where the tail is wagging the dog. There were more money for the attorneys than for the actual victim of the violation of the law. So it is Halloween. Michael, I agree with you. It's scary for any litigant because plaintiffs would have walked away for 600, and boy, did they get a multiplier in this case.
Yeah.
Right, Alan?
Yeah. Yeah.
which now Now that we move from the scary stuff, hopefully the last case that we're going to mention today is a holding that is not scary. It's on page 7 of the materials. And it's a case that I believe that you're going to be discussing because it deals with 2025 and artificial intelligence, right?
Yes, this is Nolan versus the Land of the Free LP. This case is a warning to all attorneys about the use of AI. And not just the use. AI is here. I love it, but it's the improper use of AI. Effectively, long story short, plaintiff's underlying case, employment. I think plaintiff lost on a motion for summary judgment, appealed. Plaintiff's opening brief relied on fabricated quotations from cases and hallucinated cases. So both existing cases, but just misquotes, mischaracterizations, and then cases that just did not exist. And the court, I believe this is the first California Court of Appeal opinion on this topic. There have been a few in the Ninth Circuit, probably trial courts as well, but this is the first. And effectively, the court's message is all attorneys are required to review every single case cited in a brief, whether or not created by AI. So I think that's just a general principle that applies, but you also have to be especially careful with AI. That's the primary takeaway. AI is developing, it's here to stay. It's a fantastic resource, but it's not infallible. It does not replace attorneys, especially in employment where everything is super nuanced and fact specific. It's really important that our eyes are on it. Hallucination of cases is not the only issue. Mischaracterization is because of the complexity of employment, especially, at least in my view. And just two warnings that I'm seeing in litigation is a lot of judges are starting to roll out rules about AI and certain disclosures that attorneys are required to make regarding the use of AI. So local rules should be checked, chamber rules should be checked. And, you know, I can tell you on the defense side, I do check plaintiffs' briefs, both with AI and myself, to flag any misrepresentations, mischaracterizations, or hallucinated claims, or hallucinated cases. So people are paying attention, and we also have to be while we're drafting.
Stern warning, Michael, does AI affect from the plaintiff's perspective? This warning from the court.
Yeah, I think certainly that the court saying that a $10,000 sanction is conservative in such a situation is a good warning to people to say, hey, look, don't mess around with this stuff. I think certainly it's an effective tool, but you can't turn your brain off. You still have to be the attorney. And the one thing I thought was really interesting about this case was that the defendant hadn't mentioned in their brief that there were problems with the plaintiff's citations, and this was something that the court found out. So I would say, you know, do as Alam does and would advise, make sure you're checking what the other side's saying, because you might find out maybe their stuff is wrong.
And interesting, as you mentioned, Michael, that it was the court who brought it up.
Yeah.
So there's an opportunity for all of us to check, as Alan does, the other side's work, which seems like a lot of work, but in this case, justice is more important than just the play-by-play and the fight. Well, Thank you, Alan. Thank you, Michael, for your time. Thank you for discussing these cases for everybody. I thank you for your paying attention and staying with us. I ask that you please check the Orange County Bar Association's website at ocbar.org for our next in-person meeting. Join us for the in-person meetings. They usually have interesting discussions and debates where all of us benefits and take away on the practice of law, employment law in California and in the County of Orange in general. Again, thank you and see you soon.
Thank you both.
Thank you.